Welcome to meeting number 38 of the House of Commons Standing Committee on Justice and Human Rights. Today we have MP Alice Wong, who's replacing Mr. Moore for the first hour. Welcome, Ms. Wong. Great to have you on our committee today. We'll be continuing our study on the Victims' Bill of Rights, as members know. So we welcome our witnesses that are here today, and just a note for the witnesses. That interpretation services are available at the bottom of your screen with the globe icon. If you can please select the language that you would like to listen to, you can speak in any of our official languages. So before we go to our witnesses today, we would like to pass the operational budget for these hearings. So the budget, which is distributed to all members yesterday, is in the amount of $2,550, and it will serve to pay for our expenses for this current study. Do I have the approval of everyone? Thumbs up. Wonderful. So carried. Thank you, everyone. So I'll welcome our witnesses today. I know that we're still waiting for Mr. Niemi from the Center for Research Action on Race Relations, but we do have present here today kids with incarcerated parents, KIP Canada, represented by Jessica Reed, who is the Executive Director of Programs and Research. And we also have the Canadian Bar Association, represented by Jody Burks, who's the chair in the Criminal Justice section. And for the witnesses and for members, I do keep time for everyone. I have a 1-minute card and a 30-second card that will allow you to track yourselves with your opening statements as well as your questioning. So with that, we'll go to Jessica Reed for 5 minutes for your opening remarks before we carry on. Please go ahead. Your time starts now.
Good morning, Madam Chair and Committee. I would like to thank you for the opportunity to speak on the importance of including children with incarcerated parents in the Canadian Victims' Bill of Rights and provide recommendations to protect their rights, support healing, and ultimately help to break the cycle of intergenerational trauma and criminality. After witnessing the devastating impact of parental incarceration as an educator 10 years ago, I developed KIP Canada. Currently, we are one of the only organizations in this country that specifically provides support for children who've been affected by their parents' involvement in the justice system. As a practitioner, educator, and researcher, I've seen the desperate need for policy changes to better support the over 370,000 innocent children who are affected in Canada. For decades, children of incarcerated parents have been referred to as the invisible and forgotten victims. Despite the ripple effects of parental criminality on children's well-being, economic security, and developmental outcomes, they have yet to be recognized and supported as victims of crime in Canada. However, these effects are consistent with the bill's definition of a victim. First, we must recognize and acknowledge parental criminality often occur in the context of intergenerational trauma and systematic oppression, where marginalized children are disproportionately impacted and are exposed to mental health and substance use concerns, poverty, and other adverse childhood experiences, which only exacerbate the effects on their well-being. Parental criminality has consistently resulted in children enduring emotional harm, stigma, and isolation. Researchers have found that 1 in 5 children are present at their parents' arrest. In many cases, children witness weapons being drawn at their parents and their homes being raided. Due to the nature of this trauma, children often experience post-traumatic stress symptoms, separation anxiety, and even developmental regression. Moreover, children grieve the loss of their parents as they have difficulty maintaining contact during incarceration with the financial, geographic, and policy barriers that currently exist. Scholars have now identified parental incarceration as an adverse childhood experience due to the lifelong impact it has on development and well-being. Specifically, research has shown that children who are separated from an incarcerated parent before 18 years old have an elevated risk of mental health concerns, physical illness, and negative developmental outcomes throughout life. Without support, it is estimated children with incarcerated parents are 4 to 7 times more likely to become in conflict with the law. These highlight the importance of recognizing children impacted by parental incarceration as victims in the bill and providing effective support to mitigate their effects. Consistent with research, our programs and supports at KIP Canada have demonstrated the impact of providing early intervention and supporting the unique needs of children affected by parental incarceration that are guided by their voices and based on trauma-informed, strength-based, and anti-oppressive practices. In particular, counseling, after-school and mentoring programs, peer support groups, and family visits have been effective in supporting children and youth at all phases of the justice system. Overall, these supports have been instrumental in enhancing their well-being, developing protective factors, and yielding positive outcomes while reducing the cycle of intergenerational criminality. Based on research, practice, the UN Convention on the Rights of the Child, and our Youth Advisory, we have 5 recommendations. The first, children of incarcerated parents should be included into the Canadian Victims' Bill of Rights. 2, the best interests of children of incarcerated parents, as they identify them to be, should be considered at all phases of the justice system. 3, amend policy to reduce barriers and enable children to maintain contact with their parents, such as lowering age restrictions. 4, invest in early interventions tailored to the unique needs of children of incarcerated parents. And 5, improve communication and collaboration between the justice, child welfare, education, and mental health systems to increase access to wraparound support for children and families. In Canada, every child's life and trauma should matter, and yet children of incarcerated parents remain the forgotten victims. It's time we recognize the significance of the trauma associated with parental criminality and effectively respond by including these victims in this bill and providing the support they deserve. This proactive response would help to address the effects of intergenerational trauma, reduce systematic barriers, and support the healing for the invisible victims while being one of the most effective crime prevention strategies that our country can invest in. Thank you.
Thank you very much, Ms. Reid. We'll now go to the Canadian Bar Association with Mr. Burks for 5 minutes. Please go ahead.
Good morning, Madam Chair and honorable members of the committee. My name is Jody Burks, and I am chair of the Canadian Bar Association Criminal Justice Section. I join you today from the traditional territory of the Wendat Anishinaabe Nation, the Haudenosaunee Confederacy, the Mississaugas of the Credit First Nation, and the Métis Nation. This land is covered by the Dish with One Spoon Treaty. Thank you for inviting the CBA to participate in the committee's study of the Canadian Victims' Bill of Rights, which I will refer to as the CVBR. One of the things that the CBA Justice Section prides itself on is that our members come from both the Crown and defense bars. As such, we can bring a unique, comprehensive perspective to how legislation is implemented in the criminal justice system. L'ABC.
The CBA is a national association of over 36,000 lawyers across the country. The primary objective of the CBA are the improvement of the law and the administration of justice. And it is to that end that we are here this morning on behalf of the Criminal Justice Section.
Although the CVBR uses the term victim, the CBA prefers to use the neutral term complainant prior to any finding of guilt. As such, when discussing the pre-trial and trial process, I will use the term complainant. I will reserve using the term victim when discussing sentencing and post-sentencing issues. As a general proposition, the section supports increasing resources to allow complainants to receive independent legal advice on the criminal justice process. Independent legal advice assists proper function of the criminal justice process by respecting the Crown's role as an independent minister of justice, not as an advocate for the complainant, and the court's role as an adjudicator, rather than a party that assists the participants in understanding and navigating the legal system. Additionally, the section supports complainants being provided information with respect to all areas outlined in sections 6 through 8 of the CVBR, with the caveat of the need for confidentiality while criminal investigations are ongoing. Similarly, the section supports sections 9 through 13 of the CVBR regarding complainant protection. For the most part, these were already dealt with through the sections of the Criminal Code regarding bail, obstruction of justice offenses, publication bans, third-party records applications, and testimonial accommodations such as screens, remote testimony, and the use of support persons while giving testimony. On the other hand, the section is concerned about expanding the role for complainants in criminal prosecutions, which can result in the creation of unreasonable expectations or conflicts between Crown prosecutors and complainants. For example, Section 14 of the CVBR states, every victim has the right to convey their views about decisions to be made by appropriate authorities in the criminal justice system that affect the victim's rights under this act and to have those views considered. The Crown's legal and ethical obligation is not to secure a conviction, but to ensure that all relevant facts are placed before judge and jury so that justice may be done. As such, they must be allowed unfettered discretion in choosing how to prosecute offenses. Similarly, decisions on whether to continue or withdraw prosecutions must remain within the Crown's discretion. While it is appropriate to solicit a complainant's views on procedural issues, and in determining whether to continue a prosecution, the Crown cannot be bound by those wishes. This operates the same regardless of whether the complainant's desire is to continue or withdraw a prosecution. The section acknowledges that the CVBR requires Crown to discuss and inform complainants about trial applications. However, we voiced concern about the amendments to the Criminal Code in Bill C-51, which granted standing to complainants for certain trial applications and sexual assault prosecutions. The addition of a third party with the right to make submissions about the law is problematic for two reasons. It has the potential to create friction between the Crown, the party in charge of prosecuting offenses, and the complainant, likely the main Crown witness. And two, it has the potential to complicate and lengthen pretrial applications, as well as the potential to cause mistrials, which squander judicial resources. In summary, the CBA Criminal Justice Section welcomes additional resources to support providing complainants with information and assistance in the criminal process. On the other hand, we suggest that prosecution decisions, including responding to legal arguments, be left in the capable hands of Crown prosecutors. Madam Chair, I know I am out of time, but if you can indulge me for a few more seconds. This is my third appearance before this committee, and I want to thank you for the opportunity. I found your questions thoughtful and engaging, and I wish every Canadian had the opportunity to experience their democracy in this way. Lastly, I want to thank each and every member of the committee staff and technical support. All of you exemplify the highest standards of professionalism. Thank you.
Thank you very much for that, Mr. Burks. You didn't go too much over time, and I appreciate that. So I've just been notified that the Center for Research Action on Race Relations, represented by Mr. Niemi, will not be able to make it to the committee today, and so has offered to send in his speaking notes. Now, if members agree, we can append that to today's evidence. I'll see a thumbs up if that's okay with members. Okay, great. Thank you, everyone, for your understanding and your cooperation. We'll now then go into our first round of questions. And I believe we are starting with Mr. Lewis this morning for 6 minutes. Go ahead, Mr. Lewis.
Well, thank you very much, Madam Chair, and thank you to both the witnesses. Incredible testimony once again. It never ceases to amaze me, the testimony and the witnesses that come to Justice Committee. So thank you to both. First, two questions through you, Madam Chair, to Mr. Burks. Some provinces provide legal advice to victims of sexual assault. Do you believe the Victims' Bill of Rights should include specific rights for victims of certain kinds of offenses, such as sexual assault?
Thank you very much for that question, Madam Chair. If I might respond, please. I think that more information is better. I think that all participants in the justice system should receive comprehensive information about their rights and responsibilities, regardless of what offense they either face or that they are complainants involving in. I don't know if we need to single out any specific offenses in the Victims' Bill of Rights. I do know that certain funding should be prioritized to deal with offenses that are particularly difficult in nature, complicated on complainants, and have historically been gendered. So to answer your question, no, I don't think we need to specifically designate that, but I think when creating priorities for funding and resourcing for complainants in criminal offenses, that's where the decision can be made. Thank you.
And thank you for the answer. And again, through you, Madam Chair, to Mr. Burks, just a follow up to that. So should a right to counsel for victims in certain cases be integrated into the Victims' Bill of Rights? And if so, how would you see that operating?
Thank you very much for that question. Madam Chair, if I might be able to respond to that. I don't know. So certainly any complainant in any criminal matter always has the right to retain counsel. There is no restriction on that. And the question, I guess, boils down to who is going to pay for that service? I myself, though I am a criminal defense lawyer, often provide independent legal advice to complainants in various matters, financial crimes, domestic crimes, and various other offenses. I provide them comprehensive information on what their rights and responsibilities are, and I find that it assists them very much in understanding a system that can be confusing, overwhelming, and sometimes scary, both to complainants and defendants. The question that I think your question focuses in on is who is going to pay for that? If we give a right to that, then that right has got to be funded. And is that going to be funded on the federal level or the provincial level? At this time, there are various provinces that fund clinics, and I, for one, and the CBA, on behalf of the CBA, welcome additional funding. I don't know if you have to give a specific right to counsel, since that right already exists and no one is looking to take that away. Thank you very much.
Thank you, Mr. Burks. And again, through you, Madam Chair, and this could be to Ms. Reid or Mr. Burks. I would like to get Ms. Reid's opinion on this question, please. It is important that victims across Canada are able to assert their rights no matter where they live. I'd open this question again to either one of the panel members. Excuse me. Do you have any feedback or suggestions on the ability for victims to assert their rights based on where they live or their identity?
Who was that for, Mr. Lewis?
To either of the panelists, please, or witnesses, Madam Chair.
Ms. Reid, Mr. Burks, you're welcome to take this.
Thank you, Madam Chair. I'll just give some brief remarks. I think a pan-Canadian strategy and the role of the federal government, as with all justice issues, is to sit down and develop best practices to ensure comprehensive information is being provided to complainants throughout the country, that a complainant's information is not compromised depending on where he or she lives or what he or she's background is. It should be available in as many languages as we can translate it into. And a model can be put out by the Federal Department of Justice and then disseminated with best practices. Thank you.
Thank you, sir, for that. And I got 1 minute. You've already told me, Madam Chair, you're the greatest. I was going to say that I'm not like Mr. Maloney and I don't keep track of my time. So thank you for keeping track of my time. Last question. Is there a need for greater outreach to tailor programs and policies to better meet the needs of victims in specific communities? Thank you, Madam Chair. And sorry, that is to Ms. Reid.
Thank you for the question. Madam Chair, I absolutely believe that we need to be investing into diverse outreach strategies so that we can connect supports and resources for all victims, however one defines victims, and to be inclusive so that we can help to connect them to the supports needed.
Point d'ordre, Madame la Présidente.
Madam Chair, a point of order. I think there was no interpretation as on Ms. Reid's answer there. Maybe there was a technical problem. Yes, the sound quality is very poor, unfortunately. I don't know if Ms. Reid...
If I can just go to the clerks and see if perhaps we're having any challenges with the sound or the interpretation.
Yes, we do actually. I will be conferring with the technician, but yeah, the sound from this witness is very low and difficult. So we will ask the technicians probably to get in touch with her. Sorry about that.
Perhaps no, it's okay. Perhaps we can first try, Ms. Reed. If you want to repeat your answer, speaking very loudly and clearly into your, I'm sure there's a boom on your headset. Just try again, please.
Thank you. I do think that we need to invest into diverse outreach strategies so that we can connect to and be more inclusive into all victims so that we can help to connect them to the supports needed.
Is that okay, Monsieur Fortin? I heard that the interpretation was coming through that
Je pense que le son est pas très bon.
Well, I think that the sound isn't very good, but Ms. Reed, does she not have a boom mic on her headset? Perhaps that would help. I don't know where her microphone is.
So
Même
the
en anglais,
technician,
Even if you just listen to the floor, you can't hear it well. But I think what she's saying is important, Ms. Reed. So I'm interested, but we can't hear it well, and the interpreters are having difficulty, unfortunately.
so the technicians will be getting in touch with Ms. Reed, and I do have Mr. Maloney next. So, Mr. Maloney, do you have specific questions for Ms. Reed to start off with?
I do, yeah.
Point of order, Madam
Yes,
Chair.
Madam Finlay.
I just think if Ms. Reed tried putting her boom up a little higher, it's quite low. I don't know, but maybe that'll help.
That's an excellent suggestion, Madam Finlay. Ms. Reed, do you want to try again a sound test, just as loud as you can?
Is this better in terms of having higher? Is that helpful?
No, I'd put it down. Yeah, try that.
Better?
A little bit.
Well, I think we're going to hand you off to the experts who are better at this than us members are. So maybe one of our technicians can perhaps call you. We'll suspend for 2 minutes while we figure this out, if that's okay with members. Yes? Okay, wonderful. So we'll just suspend for 2 minutes. Don't go too far, folks. We're now going into a round of questions by Mr. Maloney for 6 minutes. Go ahead, Mr. Maloney.
Thank you, Madam Chair. I've just started my timer. First of all, I want to thank both of the witnesses. Mr. Burks, I know I was starting to think you were a committee member, not a witness. You've been here so frequently, but I say that kidding, of course, but really as an expression of gratitude, because your evidence every time in today's no exception has been very, very helpful. So thank you for that. I know how hard it is to give up the time to do this. And Ms. Reid, thank you for coming today. Thank you for being a champion of an issue that is incredibly challenging, to say the least. You are a lone voice on an issue that doesn't get a lot of support, but it's gaining more momentum thanks to you. Other members of the committee may not know this, but Ms. Reid, as part of her effort to try to raise awareness for this, has prior to the pandemic made an annual pilgrimage to Ottawa from Toronto, which doesn't sound that impressive until you learn that she did it on foot. And she did it several years in a row to try to raise awareness and raise money for the initiative. So thank you for everything you're doing. It's been challenging. One of the reasons it's challenging is that, I mean, we're talking about victims and their rights. People automatically associate victims of people who have been the victim of a crime. But a victim has a broader definition. And if you look at the definition of victim in this legislation, in my view, and you don't have to convince me, that it should also include children of people who have committed crimes. And that's why you are here today. The problem with that is it automatically sort of raises a negative connotation because you're somehow you're on the wrong side of an issue. And I understand that. And when we talk about giving special rights to special crimes, for example, and other related things, to me, that focuses on the crime and not the people. And it's the people we need to focus on. And that's what you are doing with your cause. So what do you have to say to the people who say we shouldn't be even talking about families of people who have committed crimes as part of this discussion?
Thank you for the question, Madam Chair. I hear you, and at the same point, I think by including children of incarcerated parents or those who have parents who become in conflict with the law, I think it's not to take away from those who are direct victims, but in actual to understand and to be more encompassing in terms of the label of victim and how it's defined in this bill. And by recognizing the impact that it does have on the children, we actually will strengthen and help to reduce crime in the future and actually help the healing that does exist and needs to occur so that we can change the statistics that currently are plaguing our country.
Good, thank you. I mean, look, one of the big issues we face is to try to do exactly what you just said, and that's to stop repeat offenders, to try to stop things at the source. And this would be a good example of that, in my opinion. I'm curious to know, Mr. Burks, what you think of the idea of including this group of people within the definition of victim in the Victims' Bill of Rights.
Generally speaking, my comments are less related to overall concepts and more to the functionality. But in terms of the question that's been asked, Madam Chair, it's a really important question. At the end of the day, my personal view, and I'll insert it here, is that everyone involved in the criminal justice system, from the judge down to the jurors, down to the alleged victims, to the defendants, are all human beings. And I think that the system, government needs to understand the toll that the system takes on all of the parties: judges, jurors, Crown prosecutors, defense lawyers, complainants, and defendants. And so I am all for trying to assist whomever is involved in this system with the kind of supports that will help them recover from whatever trauma they faced as a result of the alleged offense, the defendants from the trauma that they faced which caused them to commit the offense, to the jurors and people who work in the system who have to observe the aftermaths of the offense. So to answer the question directly, Madam Chair, yes, I would support expanding supports by including children of defendants as victims.
Great, thank you. And I think it's important too, because one of the aspects of the word victim in this context is innocence, whether it's stated or implied. And I think children of the people we're talking about are clearly in that category. And back to you, Ms. Reed. I mean, a lot of the times you're dealing with children of single parents. So can you explain the greater impact it has when you're dealing with a child of somebody who has only one parent who's been incarcerated and who is completely innocent and has played no part in the crime whatsoever?
Thank you for the question, Madam Chair. Yes, so for children whose parents are involved in the justice system, and for many children, actually, sometimes both parents are, and so that they actually end up in foster care, which also magnitudes the effect. But even in a single parent household, they experience financial strain into the home, and so there's a lot of emotional stress that children have to go through and face. And many of them are living in communities where there are limited resources to support them as they navigate the challenges in our systems, from our education system to our health care system. And so it is so important to recognize the ripple effects that it has on the children and the family as a whole. And by recognizing the impact that it does have and connecting them to resources, we can actually help to break that cycle, which is so very important.
Thank you very much.
Thank you, Madam Chair.
Thank you, Mr. Maloney. We'll now go to Monsieur Fortin for 6 minutes. Please go ahead, sir.
Merci, Madame.
Thank you, Madam Chair. And thank you, Ms. Reed and Mr. Burks, for being here this morning. It's true that we see you very often, Mr. Burks, but it's always a pleasure. Thank you for being there. Ms. Reed, I didn't know about your capabilities in terms of walking, but that's impressive, Toronto, Ottawa. I'm also impressed by the file that you are leading with here. It's not an easy issue, parents who are incarcerated, and it really touched me when I saw that. I think that these are people that are forgotten by the justice system often. I'd also like to hear you speak about the other aspect of that. That is to say, the children of people who are incarcerated is one thing, but the parents of young people who are incarcerated, is that an aspect that you have dealt with as well? Because I didn't hear that is part of what you were talking about, but that exists, parents of people who are incarcerated?
Thank you, Madam Chair. Yes, that is very much a part, is a group of individuals that we also need to care about. In terms of the work that we do at KIP Canada, our focus is on the children and the youth, and by extension, their families. And certainly for some families whose children become involved in the justice system, we also do need to support the parents. I do think when it involves children, though, there's an extra level of trauma and stress that is put on them when their parents are inside, but we must also recognize the impact that anyone's involvement into the justice system has on the family as a whole, including parents.
Okay.
And what, in your opinion, are the main services that these people need? Because we can easily imagine that they need psychological support, because this is traumatizing, both for parents and children in this situation. But I also imagine there would be significant economic consequences, significant economic losses in all of these cases. So as I understand, they need legal counsel. So what do they have a right to? They have the right to intervene in trials, but at what stage and how is this done? So in your opinion, in supporting these people, these indirect victims of crime, do we really take care of the support they need adequately?
Thank you for the question, Madam Chair. So currently in Canada, children and families affected by the justice system are are underserved. There is not the supports needed, and this is where we do need to invest resources in. In terms of the specific types of support, I agree, counseling is very important. Also, because of the stigma that is associated with having a parent involved in the justice system, children feel as if they are the only one. So connecting them to other peers, so having peer support groups, mentorship is key so that we can help to foster academic success and employment as they navigate and they grow up is very important. And then in terms of, I do think they need to be included in their voices at all stages of the justice system when we are making decisions that do impact them. And then lastly, we know how important it is for children to have contact with their parents. If we were talking about rehabilitating the family unit, if it is the desire of the child to wish to have that contact, we need to make sure that we are creating opportunities to facilitate that and reducing the barriers, which currently there are many barriers to that.
Comment on pourrait améliorer le...
How could we improve the system, in your opinion, Ms. Reid? How could we ensure that these victims be better informed of their rights and supported? Is it not the ombudsman who should be offering services, or the Crown in charge of the trial? How should it be structured, in your opinion?
Thank you for your question. I do think it needs to be a collaborative approach. I think we need to work together in our systems. I think there are some supports that need to happen at the community level through organizations like ours because of the stigma. I do think the justice system needs to be a part directly in terms of advocating for their rights, but I do think it needs to be a collaborative approach as the needs are diverse and they intersect all systems. And so we need to be working together and have more of a holistic approach in supporting the children.
Currently, this assistance, legal counsel, for example, who offers that service currently? Is it the Ombudsman Office, I think?
In terms of this is not my area of expertise. Okay. I know from my experience with our kids that we support, they have not had like legal representation in their parents' case, any of their cases in terms of their rights.
Est-ce qu'on fait appel à vous à l'occasion?
Are you called upon on occasion to support these people through the justice system? For example, if to tell them that they might have the right to make a statement during the trial, is that kind of support, does it exist? And if it does, are you offering it?
Peut-être pas non plus.
Perhaps it doesn't exist.
No.
So to my understanding, it doesn't exist. It is something that as an organization, we're always looking to expand our support so that we can, improve outcomes and increase and protect the rights of our children and youth that we support. So that is something that we'd be open to for sure.
Est-ce que vous les accompagnez? Merci, Madame la...
Thank you, Madam Chair. Thank you, Ms. Reid. Thank you, Mr. Fortin.
Go to Mr. Garrison for 6 minutes. Please go ahead.
Thank you very much, Madam Chair, and I'd like to thank both the witnesses for being with us today. I want to express particular thanks to Ms. Reid because as someone who taught criminal justice for 20 years before coming to Parliament, I rarely ever dealt with the issue of children with parents who are incarcerated except on an individual basis. And so I do think that you've done quite useful work in bringing our attention to this question more systematically. My question is about the characteristics of children. Because we know that certain groups in our society, the marginalized groups, Indigenous people, racialized Canadians are vastly overrepresented in our prison system. I'm assuming then, therefore, that the characteristics of children with parents incarcerated reflect that fact. And I wonder if you could comment on that.
Thank you for that wonderful question. Madam Chair, yes, that is in fact the case. The majority of the children we support do identify as marginalized and racialized members of our communities.
And my assumption then is this would also be groups of children who quite often lack resources that other groups of children might have in our society. And so therefore the support services would be even more critical for these children.
Thank you, Madam Chair. Absolutely, that's exactly what happens. So they are marginalized and oppressed in all the systems, and they have lack of supports in the communities that they reside in.
And most of the, I guess, services we're talking about are provided at the provincial level. And so I'm wondering whether you think that adding children with parents who are incarcerated as victims specifically, will that help secure delivery of provincial services?
Thank you. I do believe that by including them into this bill, it actually is the first step to raising awareness. I think the first piece is that children, they are invisible and they're often forgotten about in this conversation. So I think by including them into this bill is the first start. And then and subsequently, I think it then creates a platform for advocacy to build supports across the country. I already am contacted by families across the country. We provide some virtual supports, but there is the need across the country to be providing this type of support. And it is I truly believe it is one of the most effective ways that we can reduce the cycle of trauma and criminality.
Thanks very much, Ms. Reid. I'll turn to Mr. Terbergs now, and I do thank him for his multiple appearances here and the valuable contributions he's made to this committee. The Ombudsman for Victims of Crime has made a series of recommendations about amendments or changes to the way we deal with victims of crime. And one of those, she talks about that victims of crime have a right to complain about failure to observe their rights in the system, but they don't have any centralized system to do that or any right to redress for those complaints. Can you tell us your views on that? She's suggested that the Office of Victims of Crime should be the place for all those complaints to go.
Thank you very much for the question, Madam. If I might respond, Madam Chair. Certainly having a centralized system for redress is the most efficient way. It would also contribute to the highest level of satisfaction. The unfortunate nature of the criminal justice system, having toiled in it for over 20 years now, is a just result usually involves everyone in the process being unhappy with the result. That's kind of, when you ask a criminal lawyer, well, how do you know it was a just result? The answer is because no one was happy with it. So certainly having a centralized system for processing these complaints. And I find that generally speaking, sometimes these are structural issues that there's just no way around and people will be dissatisfied with the result no matter what. But if you provide them with the information about how the system did work in their situation and how it should work ideally, and try and provide them that information, I find that at the end of the day, that certainly, maybe they're not satisfied with the outcome, but they certainly understand the outcome. And if I might, just to follow up on something that Ms. Reid said before, there is a bill before Parliament to roll back mandatory minimum sentencing. Mandatory minimum sentencing are the single biggest cause of the overrepresentation of marginalized and Indigenous communities in jails. The devastating effects of incarcerating these individuals aren't just on those individuals, but the families and children of those individuals. This committee should take up the bill at its earliest opportunity and pass that bill as quickly as possible. The Canadian Bar Association has passed a resolution calling on Parliament to roll back mandatory minimum sentences. Thank you.
Thank you very much, Mr. Burks, for reminding us of the impacts of mandatory minimum sentences, something which my party has long advocated for removing and giving discretion back to judges in those cases. I want to ask you about another recommendation from the Ombudsman, and that's her recommendation 13, where she suggests replacing restitution in the Act with the broader concept of reparations. And her argument, which is one I've heard, is that many victims of crime aren't looking for financial compensation, even though they may have suffered losses, but they're looking for more symbolic or systemic changes in the form of reparations. Is the Bar Association supportive of expanding that concept to reparations rather than the narrower concept of restitution?
Very briefly, Mr. Burks.
As briefly as possible, Madam Chair. We are definitely, we find that complainants and victims of crime often receive more satisfaction when they are permitted to have alternate forms of sentencing, not just incarceration, but redress, sentencing circles. So we have been working with our justice partners on expanding sentencing options to include various other options. Thank you.
Thank you very much. Thank you, Mr. Garrison. We'll go into our second round, and I'm cognizant of the time. We have 6 minutes remaining in the first hour. And I understand that we do have a very hard stop at 1 p.m. Because of committee restrictions. So what I would like to do is perhaps divide those remaining 6 minutes to maybe one question per party, if members are okay with that. We'll start with Ms. Wong. Please go ahead.
Well, that probably, Madam Chair, thank you very much. And then, so we haven't really talked much about seniors, because very often seniors are very vulnerable, and it's difficult for them to actually navigate the criminal justice system. So, like, you know, and elder abuse, for example, is a major concern of mine. So, can any one of you shed light on that? Thank you. Through you, Madam Chair, of course.
Madam Chair, with your permission, I can take a stab at that very briefly. There are structural difficulties in investigating offenses involving seniors. These are vulnerable groups. They often aren't investigated by the police in the most effective manner with presenting the evidence. So the two-prong approach would be educating investigators on how to properly investigate these types of offenses, and also on the local level, having clinics that could support seniors in providing them with independent legal advice. And if I might add one thing, I was grasping for a term during the last question. It is restorative justice concepts. Thank you, Madam Chair.
Thank you for that, Mr. Burks. We'll now go to Mr. Virani for your question. Please go ahead.
Thank you very much, Madam Chair. And I'll just state on the record that I'm quite shaken, as I'm sure we all are, by the news that we've heard from London, Ontario in the last 36 hours, and it's weighing heavily upon all of us, as it should be. A horrific hate crime targeted in an act of terror against a Muslim family that have lost their lives. So I'm thinking about victims who deal with hate and victims who deal with targeted acts. And I'm wondering, and I know neither of the witnesses spoke to this directly, but I might ask Mr. Burks. Mr. Burks, you commented on a little bit about your views on C-22, the Mandatory Minimum Penalties Bill, and I share all of your views and echo them. There's also another bill before the House, which is C-21. It dovetails a little bit with this theme that I'm raising, and it talks about red flags and how you might address people who might be potentially in a situation where they might commit an act of hatred, and removing, by flagging them, helping to remove potential weapons, including firearms, from them. Would you care to opine on what kind of impact that kind of legislation would have in terms of protecting Canadians? Thanks, Mr. Burks.
Madam Chair, thank you. Thank you for the question, Madam Chair, with your permission. In the very little time that I have left, certainly having a registry of firearms that allows firearms to be tracked and determining where people have access to firearms has been helpful. Law enforcement has asked for that repeatedly and has thought of it as a good tool. Any tool that will increase safety by limiting access to firearms to people who pose a danger is something that should be looked at. The CBA doesn't have an official position on that, so I'm unable to comment any further. Thank you.
Thank you very much for that, Mr. Burks. We'll go to Monsieur Fortin for one question, sir.
Thank you, Madam Chair. Mr. Burks, I'd like to hear what you have to say about the definition of victim that we see currently in this Bill of Rights. It's quite broad. We talk about individuals having suffered, etc. So a broad definition, but perhaps isn't implemented uniformly across Canada and in Quebec. So it can be enforced differently according to the province and administration in question. So should we not perhaps have made it more specific and include in the generality of these terms that it includes, without getting into really specific situations, just for example, the families of victims and the families of the abusers who don't appear specifically in this, but should perhaps be covered. So I'd like your opinion on that, Mr. Burks.
Thank you very much for the question, Madam Chair. If I might, once again, trying to keep my comments very brief. In terms of nomenclature that we use in the criminal defense bar, the term victim is a very loaded term. And in terms of how we like to view things or how we like to term things, we prefer the term complainant to refer to the person that has made the criminal complaint. Other parties can be witnesses. Other parties can be affected by the both the charge and the operation of the justice system. And I think if you don't use the term victim to designate these people, but just call them who they are, families of the defendant, families of the complainant, and that way you focus less on labels and more on people as human beings. And that way you can address what their specific needs are. Because depending on where you sit in the courtroom, your needs are going to be vastly different. A defendant's family their immediate needs may be to have the defendant come back and serve a conditional sentence at home so you don't rip the family apart. With respect to the complainant's family, it may be counseling that is needed. So if we focus less on labels and focus more on needs, I think we will increase the level of justice for all participants in the system. Thank you.
Thank you very much. And then last but not least, Mr. Garrison, one quick question if you're able to.
Thank you very much, Madam Chair. Let me make just two quick comments. One, let me express, as I know all members of the committee have done, our shock and horror at the hate crime in London and the redoubling of our efforts to combat hate in Canada, whether it's based on Islamophobia or any other form of hatred. And the last thing I will say is that from the witnesses we've heard so far and those I know we're going to hear, these sessions have drawn our attention to the fact that the 5-year review of the legislation affecting victims of crime certainly needs to take place. And in the interest of time, let us turn to the next panel. Thank you.
Thank you very much for that, Mr. Garrison. And with that, I'd like to thank our witnesses for this panel for your very compelling testimony. If there are additional clarifications you'd like to provide or additional information, please don't hesitate to send that information over to Mr. Clerk, who will circulate amongst members. Thank you, everyone. So I'll suspend now and as we prepare for our next panel. Thanks, everyone. And before I continue, Ms. Wong, I see that your hand is raised. Is this a point of order?
Madam Chair, just want to clarify if Mr. Moore is now in the committee, because I'm subbing him. So presumably if you say in, then I can leave.
I just noticed Mr. Moore is now with us. So I suspect that you're ready to leave. Mr. Moore, would you like to do a quick sound check?
I'm here. Thank you, Alice, for filling in for me while I was out. Look forward to the second half of the meeting.
Thank you
Good
very
afternoon.
much. And thank you, everybody. It's been a very good learning session. Thank you.
Thank you, Ms. Wong. So I'll call this meeting back to order and welcome our witnesses for taking the time to be here today. And just for members to know that interpretation is available at the bottom of your screen. Select the language that you'd like to listen to. You can speak in any of our official languages, and do speak slowly and clearly so that interpretation is easy for all of us, especially our interpreters. And when you're not speaking, just please make sure that you're on mute. And when you are speaking, it will be prudent of you to unmute yourself. I think that would be helpful. So with that, I'll welcome our witnesses. We have the Honorable Pierre-Hugues Boisvenu, my apologies for having mispronounced that, who is a senator. Welcome to our committee. We also have Dr. Joanne
Merci,
Wemmers.
Madam Chair.
We also have Dr. Joanne Wemmers, who is a full professor, School of Criminology, International Center for Comparative Criminology at Université de Montréal. And lastly, we have from the Criminal Lawyers Association, Leo Russomano, who is a lawyer. And I have been advised that Mr. Russomano did not conduct his sound test before the meeting started. So Mr. Russomano, I'll just say to you, please make sure that you're speaking very slowly and clearly and loudly so that we don't have any delays in the interpretation. And as witnesses may know, I have these 1-minute cards and these 30-second cards to help you keep time of your opening remarks. We'll start with the Honorable Senator for 5 minutes. Please go ahead, sir.
Merci.
Thank you very much, ladies and gentlemen, members of Parliament. Thank you for the opportunity to speak to you today about the importance of the Canadian Victims' Bill of Rights, adopted by the Conservative government in 2015. I worked for almost a decade on this being adopted. After the murder of my daughter Julie, I had a private meeting with Mr. Stephen Harper, and he said that they would become the defender of victims, and he kept his word. Without his efforts, this would never have come into being, and I want to thank him. The Canadian Victims' Bill of Rights was intended, first and foremost, to recognize the rights of victims of crime within the criminal justice system. This supra-constitutional law, it has to be repeated, has 4 pillars which rest on 4 fundamental rights that criminal justice stakeholders have the obligation to respect: the right to information, to participation, to protection, and to restitution. Unfortunately, since its introduction 6 years ago, far too many victims of crimes are still not treated according to the principles of the Bill of Rights. In theory, it aims to rebalance the rights of criminals and victims in the justice system by refocusing their importance of their roles. In practice, this concept is not being properly implemented, as evidenced by the final report of the 2020 review of Canada's criminal justice system. First, the report shows that victims still find it very difficult to report their crimes to the police because of fear of retribution or fear that their case will not be taken seriously. This loss of trust is the result of a justice system that's often permissive and lax towards victims of domestic violence and sexual assault in particular. Sections 9, 10, and 13 under protection are not upheld. I remind you that the majority of the 160 women murdered in Canada in 2019 had reported their abusers to police. They paid with their lives for having trusted the justice system. In the same report, a lack of compassion and respect towards victims when they're involved with the justice system is mentioned. Last fall, I tabled a bill in the Senate to help the victims' families that felt excluded when hearings were held. And even though the Senate, like your chamber, was quick to adopt the video conferencing, is it right that the parole board took almost a year to allow victims' families to attend hearings? As a result, Section 8 on the right of information has not been upheld. And there is a direct lack of action that has been taken by this government to deal with its own institutions and enforce it with its own institutions. When a law as complex as this is implemented, the government has a duty to ensure that it is enforced and that improvements are ongoing. The 2020 progress report on the Canadian Victims' Bill of Rights by the Office of the Federal Ombudsman for Victims tells us that there are limited training opportunities for criminal justice officials, and there's no campaign to inform victims and the public of their rights. The government has the first key issue raised in the report is about the lack of legal recourse for noncompliance. When victims' rights are violated, they cannot appeal to the courts. They can still file complaints with the organization involved, but no mechanism for managing these complaints has been put in place, as was foreseen in the Bill of Rights when it was adopted in 2015. To address this issue, it is imperative that the first recommendation of the report be implemented, and I quote, delete sections 27, 28, and 29 of the Canadian Victims' Bill of Rights, which deny victims any standing to appeal to courts for review when their rights are not upheld. The other important point is a change that is urgently needed, in my opinion. The Office of the Federal Ombudsman for Victims reports directly to the Department of Justice and the Minister. Because of the importance of the Ombudsman's mandate, its independence from the Minister of Justice should be imperative, and legislation should be enacted to make the Ombudsman an officer of Parliament. As well, the Office of the Ombudsman should be the sole authority for the review of complaints from victims of crime about the way that they have been treated by a federal department or agency. If the correctional investigator reports to Parliament, why not to the Ombudsman for victims of crime? Members of Parliament, the 5-year review of the legislation is a must. In 2015, we were aware that we had just given victims a vehicle for the legal recognition of their rights. Unfortunately, since its adoption, the federal government has forgotten to maintain this vehicle, and worse, it has not placed anyone on board to drive it. It is up to you now to decide the fate of this charter. Without a 5-year review to hear the voices and opinions of victims, our justice system will struggle to restore the trust that victims have lost in the Canadian justice system. Thank you very much. I'm ready to answer your questions.
Much, Senator Boisvenu, and thank you for sharing your story with us. We'll now go to Dr. Wemmers for 5 minutes. Please go ahead.
Thank you. And it's an honor to be here. Thank you for inviting me. I would like to, so when we look at the Victims' Bill of Rights, it clearly represents a step forward. But there remain several issues that need to be addressed. And Canada has a responsibility to ensure that the 1985 UN Declaration of Justice for Victims of Crime and Abuse of Power, for which Canada was one of the countries that took the initiative to develop, is respected across the country. And unfortunately, currently, Canada does not meet these minimum standards and norms for victims of crime. Key topics that are included in the UN Declaration, such as state compensation, victim support, and restorative justice, are not included in the Victims' Bill of Rights. For example, according to Articles 12 and 13 of the UN Declaration, states should create compensation programs for victims of violence. Currently in Canada, not all provinces and territories have such programs. This inequality needs to be addressed in order to ensure that all Canadians have access to the minimum standards identified by the United Nations, and the Victims' Bill of Rights should be modified to include these basic rights for victims. Specifically, amend Victims' Bill of Rights to include access to victim support, restorative justice, and state compensation programs. Secondly, restitution. In order to execute a restitution order, Article 17 of the Victims' Bill of Rights refers victims to civil tribunals. However, a civil judgment does not really help victims. We know this. This is well known for 20, 30 years in the research. Recognizing the inadequacy of such a provision, other countries have made the state, rather than victims, responsible for enforcing restitution orders, treating them like they treat fines. The state already has mechanisms in place to ensure that fines are paid, and these systems can be used to retrieve restitution owed by offenders. I addressed this in the research brief, Restitution in the Context of Criminal Justice, which I attached with my documents yesterday. It's available in both English and in French. Thirdly, language. Article 3 of the UN Declaration states that all victims should have access to rights and services regardless of their language, race, gender, age, etc. Canada is officially bilingual, not to mention the many other languages, Indigenous languages found in Canada. The criminal justice system is set up to accommodate the linguistic needs of the accused, of offenders. However, it does not address the linguistic needs of victims. An example which is not uncommon, unfortunately, in Montreal courts is when one party, the offender, for example, speaks one language, such as English, and the victim speaks another, such as French. The accused has access to translation services, and rightly so, but the victim does not. And a victim who wishes to attend the trial and follow the case, they cannot even ask a friend, a bilingual friend, to accompany them and to help translate, as they are members of the public, they sit in the public tribunal, and no one's allowed to speak during the trial. This problem is not limited to the courtroom either. Services such as compensation programs often have unilingual websites, forms, etc. So specifically, the Victims' Bill of Rights should be amended to include equal access to rights and services regardless of language, race, gender, age, etc. Fourthly, the rights in the Victims' Bill of Rights are non-enforceable rights, and I was quite happy to see Senator raise this issue as well. This means that when victims' rights are not respected, they have no recourse. What good are rights if they are not enforceable? Victims are powerless against an omnipotent state that has the power to force them to testify, as well as the power to shut them out. We need to recognize that crime is a violation of victims' human rights, as well as an offense against society. Treating victims with dignity and respect means recognizing them as persons before the law, with rights and with recourse. The Victims' Bill of Rights must be amended to include an enforcement mechanism. Otherwise, to quote Ontario Judge Gerald Day, one can only conclude that the legislator did not intend for the Victims' Bill of Rights to provide rights to victims. And I quote this from the decision in Vanscoy and Evans in 1999, when two victims brought this case to the government when their rights, as stated in the Ontario Victims' Bill of Rights, were not respected. I have attached a copy of Chapter 7 of my book, Victimology, A Canadian Perspective, in which I discuss victims' rights in Canada and abroad. Specifically, Articles 27, 28, 29 of the Victims' Bill of Rights should be deleted. They should be replaced with an enforcement mechanism. Modify the language of the Victims' Bill of Rights, including Article 20, to acknowledge victims' human rights and recognize that victims, the crime constitutes a violation of their human rights.
Thank you. Thank you very much, Dr. Wemmers. I will now go to Mr. Leo Russomanno for 5 minutes. Go ahead, sir.
Yes, good afternoon, everyone. On behalf of the Criminal Lawyers Association, thank you for having us back to appear on this important bill. As I recall it, approximately 5-6 years ago, I was present before the Senate committee to speak about this bill, and I think it's an important exercise for the committee to review bills after they've been enacted to evaluate their performance. I don't intend to use up my full 5 minutes. In my experience, more of the useful dialogue happens when we're exchanging questions and answers with committee members, but I will say this. Criminal Lawyers Association includes members that practice criminal law primarily. That includes also providing independent legal advice to complainants and alleged victims, including in my own practice. I've taken on many files involving independent legal advice to witnesses and alleged victims and complainants. So I think there's an important perspective here, but the perspective of the Criminal Lawyers Association, I think, is really in relation to questions that the members might have about how some of these changes might play out on the ground in trial courts. As a general observation, I should say that I think the Criminal Lawyers Association is concerned where aspirations don't match reality on the ground and investment in the criminal justice system. So we could aspire to create a better system, but without providing the means for that on the ground through investment in the system, investment in access to justice models, those become simply hollow words on paper. Access to justice is a buzzword. Everyone loves talking about access to justice. And oftentimes, in my experience, when the rubber hits the road, when it comes to actually investing in the criminal justice system, that becomes merely a tagline. Without any follow-up and without any investment, access to justice will remain an elusive goal. But I do think it's important to address some of these issues, as well as the understanding that victims and witnesses and complainants have of the criminal justice system. I'll leave it at that for now, and I welcome any comments or questions from the members of the committee. Thank you.
Thank you very much for that, Mr. Russomanno. We'll now go into our first round of questions for 6 minutes each, starting with Madame Findlay. Please go ahead.
Well, thank you very much to the witnesses here today. There's been some powerful testimony, so I really appreciate it, and with specific ideas, which is very helpful. So thank you so much. Speaking to Senator Boisvenu for a moment. Hi, Senator. I thank you for your work on Bill
Bonjour.
S-231. Bonjour and bienvenue. Intimate partner violence is something this committee has recently studied, and we repeatedly heard that the existing protections for victims of domestic violence isn't always sufficient. We had testimony from Chief Durapa of the Peel Regional Police, Kamal Dillon, a survivor, and others. Could you expand on what more needs to be done to protect victims of domestic violence, and specifically how Bill S-231 might better support these victims? You have some comments on that?
First of all, I would like to tell the committee that this bill was written after speaking with some 100 women who were all victims of domestic violence, many of whom were victims of attempted murder. So we absolutely asked what they wanted to see in changes to the criminal code. There were three components that were emphasized, but to better control abusers when they're at the trial process by using electronic bracelets, and it's already used in some parts of Canada and other countries. Second, to change the criminal code to make it so necessary to work faster on these, because men are usually the ones who are controlling the victims in this. And thirdly, to make changes to the criminal code in terms of orders to keep the peace and be of good governance, and for domestic settings. So that doesn't really exist right now. So these are first initial steps that we could take to better protect women and to reduce the number of murders in Canada as well. Because in Quebec, we see the equivalent of the massacre at Polytechnique. Some 12 to 15 women are killed every year in our province, and the pandemic has really increased the number of those crimes. So it's very important. My colleague, Mr. Gould, tabled such a bill in the House, and I think the House of Commons should pass that bill quickly because lives depend on it.
Thank you. The Office of the Federal Ombudsman's 2020 Progress Report notes, quote, based on our analysis of the data available to us, it appears that the objectives set out in the Victims' Bill of Rights have not been met. The voices of victims and survivors are clear, and our own practical experience with the Act over the past 5 years has shown us that despite the primacy it was given as quasi-constitutional when it was created, its implementation has been sporadic and inconsistent. Do you agree with this statement, Senator?
Oui, tout à fait d'accord.
Yes, I agree completely. If we can make a comparison, members of Parliament. It's to compare it with the Charter of Rights and Freedoms. And since 1982, this charter has really evolved as a result of decisions by the courts. But what we haven't seen over the last 6 years with the Victims' Bill of Rights is that it's theoretically it's a vehicle, but we have to move from theory to practice. So by not managing complaints concentrated in one single place, like with, for example, the Ombudsman Office, we don't have a true picture of how it's working and of the opinions of victims. So when the Ombudsman says that his office should be the sole authority to deal with this, I agree completely. Also, we have to give him full independence, because if not, his work risks being in conflict with what he's doing on other fronts. So if he was to report directly to Parliament as an officer of Parliament, such as the correctional investigator does, it would allow him to really assess the value of the Bill of Rights, and so this independence is so important.
Thank you. You mentioned both the training of criminal justice officials, which has been limited, and the lack of public educational efforts. Do you wish to just expand on that a little bit?
Every week, every day, victims of crime contact my office and seeking support in the justice system. And when I tell these people what's in the Charter or the Bill of Rights, I am astonished to hear that Crown attorneys, prosecutors have no idea about what the Bill of Rights says, and judges and magistrates don't seem to either. So there hasn't been a comprehensive information campaign to inform these prosecutors and judges on the content of the Bill of Rights, and to tell people who knows if they're going to be the victim of a crime the next day, and they have no idea of the rights that would be offered to them within the system. So the federal government must do the same kind of international, or not international, but information campaign that they do in terms of the environment and other issues. They have to inform people of what's in this Bill of Rights, and if not, we'll be talking about the same things 5 years down the road that we're talking about today.
Thank you. I'm out of time. I have many more questions for the professor and others, but I'll leave it to my colleagues. Thanks.
Thank you very much, Madam Finley. I will go to Mr. Kellaway now for 6 minutes. Please go ahead.
Thank you, Chair, and hello, colleagues, and a special thank you to the witnesses for some important testimony today. First, before I begin, I just want to say my heart and all the hearts of people in my riding of Cape Breton-Canso go out to the victims and their families in the shooting in London, Ontario, an immense tragedy. Dr. Wemmers, the night of April 18th into the morning of April 19th, my province of Nova Scotia, we fell victim to a horrific tragedy that is known as Canada's worst mass shooting in our country's history. The gunman, he entered 16 small rural communities across my province, killing 22 people and injuring 3 others, including members of the RCMP. It's an exceptionally sad chapter in Nova Scotian and Canadian history. And just 10 days after this tragedy, our government announced an immediate ban on some 1,500 makes and models of military-grade assault-style weapons. I think we all know that victims who survive such violence are often left with emotional and physical trauma. So, Doctor, what does this ban mean for these sorts of victims of gun violence or victims of other forms of crime like domestic violence? And you spoke to this in some detail in your opening statement, but this is a chance for you to unpack some of those points that you made in terms of, do you think our government could be doing more to support victims of gun violence or their families moving forward?
Thank you for that question. Yes, I think we can do more. If I think in particular, the question of compensation for victims of violence, and I look at Nova Scotia, for example, and what it offers in terms of state compensation for victims of crime is very limited. It's psychological care, which is very important, but that's it. That's all it's offered. And there are, as a result, great differences across Canada, where some provinces offer absolutely nothing. In Newfoundland, there's nothing. In the territories, there's nothing. And that is unacceptable. So yes, a lot has to be done. A lot more can be done to make sure that Canada meets the minimum standards set out in the UN Declaration, and meets in order to meet the needs of victims. I mean, if we think about what happened recently now in London, Ontario, horrible. My first thoughts are what is available now in Ontario in terms of aid and assistance for the child that survived. Last year, Ontario government stripped into its state compensation program. What was available before, after 20 years of trying to make it better, was replaced by something that is very, very, in comparison to Quebec, for example, a minimum in terms of what services are offered. And I think that this is a real concern, that we should at least have minimum standards across the country in terms of the basic essential services are available to all Canadians who fall victims of violence. So yes, does that answer your question?
It does. I really appreciate that feedback. And I'm going to stay with you, Doctor, as well, if I may. Bill C-51, an act to amend the Criminal Code and the Department of Justice Act to make consequential amendments to another act, recently amended the Criminal Code to provide complaints in sexual assault cases with the right to participate and be represented in proceedings to determine the admissibility of evidence about their sexual history. So our government consider this an important change to support victims of sexual assault. Again, along the same lines as the last one, are there further ways, Doctor, through the Victims' Bill of Rights or otherwise, that our government could support victims of sexual assault?
Yes, and I would go further saying all victims, but start with victims of sexual assault. Yes, very important step, that modification, in terms of a first step towards recognizing victims as persons before the law, with a right to privacy, with a right to safety. Victims' rights are human rights. And I think that this is important. At the Université de Montréal, we are starting, as of September, a legal aid clinic for victims of crime. And I think that this is important in terms of informing victims of what the law is, informing victims of what their rights are, and recognizing that victims have a legitimate interest in the criminal justice process, that they are more than just witnesses to a crime against the state. And I think the legislation that you just mentioned goes one step, a first step. And a second step would be enforceable rights for victims. So taking the Victims' Bill of Rights and adding some sort of recourse for victims.
I wrote down as you, after you said it, victim rights are human rights. And I think that is profoundly impactful, Doctor. And it's something that just completely resonated with me. I have 1 minute left. In terms of anything else with respect to supporting or adding to support beyond the compensation that you referenced, and of course victim rights are human rights, are there other tweaks that we could look at to strengthen? Like you say, we're going down the right path, which is amazing and important. What else could we be doing beyond some of the things that you mentioned that you could take the next 30 seconds to provide us some insight on?
Well, I think enforceable rights would be the most important thing, in all honesty. If we start with that, and we start with some sort of recourse for victims, that they and identifying also who is responsible for what. Now it just says in the charter responsible authorities or something. We have one criminal code in Canada. We should be able to identify who does what, and when it's the police who's responsible for something, and when it's the prosecutor, because as long as it remains ambiguous, no one will own up, and it will lead to a lot of confusion and ambiguity for victims as well. So it's important to make them enforceable rights, but also clarity in the bill in terms of who is responsible for respecting which rights of victims.
Thank you, Doctor.
Thank you.
Thank you very much, Mr. Callaway. Senator Boisvenu, I see your hand is raised. Is this, are you having difficulties?
Yes, I just would like to add a comment on the concept of
out of time, so perhaps in the next round of questions, we're just going to start with Monsieur Fortin. Merci beaucoup. We're going to start with Monsieur Fortin for 6 minutes. Please go ahead, sir.
Merci,
Thank you, Madam Chair. Senator Boisvenu, I would perhaps allow you to complete what you were wanting to say, but I'd like to hear Ms. Vemmers on two issues. First of all, I understand, and I like the concept that there are 4 subjects that are of interest here, but the implementation of the mechanisms, in your opinion, Ms. Vemmers, I'm sorry for my pronunciation, the Ombudsman services currently in Canada, is that sufficiently adapted to various situations currently, or should it be changed? Perhaps some responsibilities that person has should be given to someone else for victims. So I'd like to hear what you think of the services offered by the Ombudsman. Thank you for the question. I feel that the Ombudsman work is fantastic. I think it's wonderful that we created that position. But as Senator Boisvenu has already said and was mentioned in the Ombudsman report, it's important to have a centralized entity to deal with the complaints, because right now complaints can be tabled all over the place and it's hard to know where the flaws are in all of this. It could be centralized within the Ombudsman office. That would help us. We'd know what the issues are and what the priorities are, what do we need to work on. So yes, it's important. So centralizing this within the Ombudsman office, in your experience and what you've seen, should we perhaps increase the funding? Will they need more staff? Because I feel like the Ombudsman's office is already overwhelmed with the work that they need to do across the country. So what do you think of that? Well, yes, of course, more resources would be helpful, and we could give more time also and more funding to carry out this work, yes. I'll change subject now, Ms. Vemmers. The remedies, you, like Senator Boisvenu, said that sections 27, 28, and 29 should be deleted from the Bill of Rights and to allow victims to appeal decisions when their rights are not respected. So what remedies should exist for victims? Because in a particular situation, if one right hasn't been complied with or upheld with, should they be able to appeal a decision, or should that person be able to ask for restitution from the accused or from the government? What sort of remedies do you think would be advantageous to victims that don't exist now because of sections 28, 27, and 29? Thank you. There are several examples that exist in other countries. I think, for example, in the United States, each of the states have their own Bill of Rights and they're binding. So this is interesting because it's a common law system like ours, but allows to have those kinds of binding decisions that be made. In Oregon, for example, there's a Mandamus Act, which also exists in the criminal code in Canada. In the civil code as well in Quebec. That's okay. I'm not a lawyer, so I think that there are experts who could perhaps address that subject. But it's interesting to see what our neighbours are doing in Australia. In the state of Victoria, there's also the possibility, or at least they're working on the possibility of having these kinds of enforceable decisions. And so there are examples in the Commonwealth that could inspire us. And if I understand well, if we look at the Mandamus example, it means that victims would have legal counsel within the Ombudsman's office that would work on these issues for them. For example, let's say this is a good example. This victim who's in the courtroom is being treated like who's just a spectator. There's no interpretation services. There's no legal counsel. Cannot intervene in the process. And we understand that we all understand that that's not what we want. That's not desirable. But how would we really articulate her needs? What should be in the Bill of Rights? Would the Ombudsman be able to send legal counsel to the courthouse when these kinds of things happen? So do you have some kind of scenario in mind, or would this be something that would yet to be determined? Well, I think when we had the first discussion on the Charter, I submitted a brief on this, and I'd be happy to send it to you. Where I presented different ideas about how this might be done. Thank you, Ms. Vemers. Now, I'll keep my word. I have less than a minute left, but I'll give Senator Boisvenu the floor. I know he wanted to say a few words, so we're listening. Thank you. The great weakness in terms of help to witnesses, if we're talking about restitutions, is because it is under the provincial areas of jurisdiction, and so 4 provinces have these services, and it's good, but it doesn't exist in the other provinces and territories, so it's not an equal ground for Canadians. So if a trial, for example, is in the trials in Toronto, and the victim is from Quebec, they won't be paid back for anything because it has to be within the province. So Canada should show some leadership and provide minimal standards that we've seen with other programs and ensure that all Canadians are treated equally, regardless of where the crime took place. It's just not normal that a Quebecer who is attacked in Vancouver would be helped neither by the province of British Columbia nor by the province of Quebec. So I think that leadership needs to be shown by the federal government within the meetings that happen amongst the ministers of justice across the country to talk about minimal standards to come to the assistance of victims of crime. Thank you, Mr. Senator Boisvenu. Thank you.
Monsieur Fortin, now we'll go to Mr. Garrison for 6 minutes. Go ahead, sir.
Thank you very much, Madam Chair. And of course, I remain frustrated by these brief series of hearings that we're doing on the Canadian Victims' Bill of Rights in the place of the review that we actually need to see, the 5-year legislative review. So I'll try to ask some quick questions here out of the myriad questions I have for these witnesses. I want to start with a question to Mr. Russell-Mano. In the Ombudsman's Victims of Crime Recommendation 1, we've talked a lot about some of the provisions, but we haven't had any one talking about her recommendation that there be established an administrative right to review decisions not to prosecute. I wonder whether Mr. Russell-Mano has any comments on that recommendation.
Well, I guess it's somewhat concerning given the notion of prosecutorial independence and the difficult decision that Crown prosecutors have to make. And being on the outside, of course, I've never been an assistant Crown attorney or a Crown attorney, but my understanding is that before withdrawing serious charges, for example, charges involving firearms, charges involving sexual assault allegations, charges of that nature, that it's not a simple matter of a Crown attorney making a unilateral decision to withdraw a charge. And my experience is really from Eastern Ontario, but I believe it's the Crown policy manual that dictates that a Crown prosecutor who has carriage of a file would have to consult with senior Crown attorneys, if not the Crown attorney of that particular jurisdiction or a deputy Crown attorney, and have a very serious discussion prior to withdrawing a charge. So it's not an off-the-cuff decision. It's not a decision that is taken unilaterally, but is one in the circumstances where, again, based on my own experiences in Eastern Ontario, these are not decisions that are taken lightly. So I guess I question what that looks like on the ground. Review of a decision would be, in what forum would that take place? I'm concerned about tying up further judicial resources where we have a system that is vastly under-resourced as it is, that faces systemic delays. And I'm concerned about how that might have an impact on prosecutorial independence going forward.
Thank you very much for that answer. I have a question for Dr. Wemmers. As a former criminologist myself, I used to tell my students that no one would design a criminal justice system like the one we have with this division of powers federally and provincially, because it was built on 19th century historic circumstances. So I think Dr. Wemmers has made a useful suggestion in the idea of establishing minimum standards for services available to victims. And I wonder if she could tell us a bit more about how she thinks that would work.
Well, I think as was mentioned also by the senator, we do it for other things like medical services, that there are at least a minimum requirements across the country, and then for the rest of the provinces fill it in the way they see fit. And I think that the point of departure would be the UN Declaration of Basic Principles of Justice for Victims of Crime and Abuse of Power. And if you wish as well, there are even better examples, for example, the Council of Europe, which are much more specific and detailed in terms of, but run in the same, along the same lines and essentially say the same thing, but with more detail, more accuracy. And in that sense, it's interesting to point out that the Council of Europe as well is currently working on a new recommendation for victims of crime as well. So it's something that we're seeing internationally, and it would be an opportunity for Canada to catch up, because where I think Canada used to be a leader when it came to victims' rights in the 80s, we seem to have lost that lead in the last 20 years, unfortunately. And it would be, I would be very happy to see us do better. We can do better.
Thank you, Dr. Wemmers. I want to ask about the, I guess I'll call it the interplay between restitution and compensation, and the idea that depending on who the offender is, some victims might end up with better restitution than others, due to the lack of compensation systems. And I wonder if you have any comments on that gap in our system.
To me as well, yes.
Yes.
Yeah, I think this is one of the reasons why restorative justice should be included in it. I was very disappointed that the Bill of Rights only talks about restitution and doesn't talk about reparation in more general, because I think it's important to recognize the other more symbolic forms of reparation that can be very satisfying for victims, and perhaps sometimes even more important, given that offenders are often without means to make restitution to the victim. I think that it would be wise to recognize that there are many potential sources of reparation and capitalize on them. That I think would be in the victim's interest as well as that of the offender.
Thank you for that. I want to ask you about an important issue that I think you raised, and that is the availability of services in both official languages to victims. And I'm going to ask you what I think is an obvious question I know the answer to. Are there any avenues of recourse in the current system for getting services such as translations or interpretation of matters for victims? Is there any recourse at this point when victims and offenders are from different language groups?
Not as a member of the public. A victim is a witness to a crime against the state. If they're there during the trial and haven't been invited as a witness, no, then they are a member of the public and have no other statute whatsoever. And I think that is a mistake. We have to recognize their legitimate interest in what is happening.
And so without that, certainly that would leave victims without any ability to, even if their rights aren't enforceable, any ability to exercise their rights within the system. Is that the central problem here? Which
is why I think we have to include the issue of language, etc., in the Bill of Rights. And again, it's in the UN Declaration. And again, look at the European Union. There are wonderful examples of how that can be dealt with in a multilingual context. There are great examples of what we can do.
I guess my last question also will go to you, Dr. Wemmers. Oh,
Mr. Garrison,
okay,
you're already well over time.
Okay, thank you.
Thank you for your patience. And members, I'm looking at the clock. We have about 10-ish minutes left of the meeting, and I just wanted to clarify something before I divide the remainder of the time for members. With respect to Mr. Niemi, I know that we had talked about appending his speaking notes to today's evidence, but I asked members, do we want to continue with what we've agreed to there, or should we be re-inviting him for this Thursday, keeping in mind that both of the panels for Thursday are filled with 3 witnesses per panel, so it may be a little bit challenging, but we'll do our best to make it work. So if members can just give me some clarification around that, that would be helpful. Mr. Garrison?
Thank you, Madam Chair. I know I may not have been the only one who suggested Mr. Niemi as a witness, but I think it's very important, given that these were technical problems that kept him from appearing, that rather than simply appending his testimony, which I said I agreed to when I thought he wasn't available, but if it was technical, I think we should invite him on Thursday and we'll deal with those challenges we have.
Thank you. Mr. Moore?
Yeah, I agree with that.
Thank you for that. And Mr. Virani?
I agree. And as I've indicated, I know Mr. Niemi is a very thoughtful individual who does tremendous work on race relations, and I think his evidence would be useful to have in person.
Perfect. Thank you for that, Mr. Virani. So based on the discussions here today, we'll go ahead and send.
You don't mind if I agree or not, Mrs. Chair?
I'm so sorry, I didn't see your hand raised, Monsieur Fortin.
No,
I usually come to you proactively.
I agree.
Thank you very much. Merci beaucoup. So what I'll do is Mr. Clerk will reach out to Mr. Niemi and offer either of the 2 hours, either the first or the second. And we'll have 4 witnesses for one of the panels then, and we'll go from there. So with the remainder time, and I realize that we have a very hard stop at 1. What I'll do, as I did in the last hour, is to offer 1 question per party. Starting with Mr. Cooper, who's appearing in person today. Go ahead, Mr. Cooper.
Great. Thank you, Madam Chair, and I'll direct my question to Senator Boisvenu, who is to be commended for his tireless advocacy and support of victims. And I want to just provide you, Senator, with an opportunity to elaborate on a point that you made respecting the need to make the Victims Ombudsman independent, to report directly to Parliament. You briefly touched upon it. Could you elaborate on that? And second of all, do you see the need or benefit to making the Ombudsman permanent as opposed to being housed in the Department of Justice? I know this was an issue that had been brought forward by our former colleague Sylvie Boucher in the way of a private member's bill in the last Parliament.
Merci, Monsieur le Député.
Thank you, Mr. Cooper, and you raising an important point. And you're yourself. I would like to offer my condolences to the community in London for those awful events. What we have to understand is the ombudsman position deals with complaints that concern all federal agencies and departments. So he'll eventually always be in a conflict of interest if he reports to a department. And I think it was in 2017 that MP Boucher tabled a bill and that was seeking to make that a permanent position because currently it is a program that's under the Department of Justice that could be done away with at any time. It's not created by statute, so it's important to make that permanent within the structure. The victims are just as important as the criminals, and because they have a permanent representative that is created by statute law. So it's as though we're second-class citizens after criminals. And so it's not my intention to take away anything from that position of the criminal investigator, but the ombudsman position should be created by law, and the ombudsman should be reporting directly to Parliament so that the minister can ask questions about any problems within the system. So I think it's a very important subject, and I hope that that will eventually be done. Your committee might study it, indeed, to put forward a proposal.
Senator, we'll now go to Mr. Sarai for your 1 question. Thank you.
Sure. Thank you, Madam Chair, and thank you for all the work all of the witnesses are doing in this regards. It's a very important issue, and sometimes much forgotten, the victims in crimes and how they're perceived. This question is going on from one of the panelists before who was talking about the children of those accused as being victims. And what I want to ask is maybe to Dr. Wemner and Mr. Russomanno, with regards to intimate person violence, where the victim ends up being the child of the, could be the child of the victim, as well as of the accused. How do you think this Bill of Rights could be amended or changed or bettered by services so that we can help those that might be a witness to the crime, might also be the child of the accused, and it also is the child of the victim? If you can quickly elaborate on that. To Dr. Wemner first.
Thank you. I think the research is increasingly clear that children are not just witnesses of domestic violence, but also the victims of domestic violence. And it's important to recognize that. So they're not indirect victims, they are direct victims as being, exposed to the violence. And we know very well the impact that it can have on them in terms of trauma. So I think that that's the first thing, is that we stop looking at them as being indirect victims, but recognize them as being the direct victims suffering trauma as a result of their exposure to violence in the household.
Thank you. And Mr. Russomanno?
Yes, I think it's a good question. I believe as it stands now, the Victims' Bill of Rights recognizes that family members of victims of crime, including in the example you've provided, would be considered victims for the purposes of this legislation. And so with the added overlap that they're also a family member of the accused, I don't think that any more would be required to have them fit under this bill. But to follow up on the comments made by a panelist in the previous session, I do think it's important to recognize that there are family members of incarcerated individuals and accused persons that also suffer greatly from the commission of crime, and that they are directly or indirectly affected in significant ways. And incarceration is obviously a massive disruption that often doesn't only affect the accused person who's being imprisoned, but rather family members as well, who lose a loved one for a significant period of time, or a source of income in which they're a dependent, emotional support. There's a variety of ways in which people who are family members of accused persons suffer greatly.
Thank you very much. We'll go to Monsieur Fortin. And we have 4 minutes left on the clock. We have to share that with Mr. Garrison. Please.
Merci, Madame la Présidente.
Thank you, Madam Chair. The question I have would be for Ms. Wemmers, Dr. Wemmers. We saw earlier that you, like Senator Boisvenu, spoke about the problem of reciprocity between provinces. The services are not the same from one to another, and we need to find a way to standardize that across the country. I understand. Now, we're talking about changes to Canadian law, so it should be simple enough to organize. But my question really is more about crimes that are committed abroad. So victims of crime abroad, for example, the mother of a child who's killed in another country, or the son of a mother who was killed in another country, the family or the husband or wife of someone who committed a crime in another country, currently under the Bill of Rights, they don't receive any support. So in your opinion, Dr. Wemmers, should the definition of victim be amended to include these people, to offer the same protection to Canadians, Quebecers who are the victims of crimes that were committed abroad as they would have here in Canada? Thank you for that. That's an interesting point. If we look at the European Union, for example, the starting point there is the state where the crime took place that should compensate the victims, even if they come from another country. What's interesting, and now in Quebec, with the new bill to replace the compensation program in Quebec, we've changed our approach. And now the victim can either seek restitution elsewhere, but if it's in another jurisdiction that doesn't have such a program, they can use the Quebec system. And I think that's an interesting option. Thank you.
And last but not least, we'll go to Mr. Garrison for the remainder 2 minutes. Go ahead, sir.
Thank you very much, Madam Chair. A question for Dr. Wemmers, who emphasized rightly restorative justice programs. Lots of those restorative justice programs are run by community-based groups who can quite often get funding, grant-based funding for projects, but quite often lack support for their core functions to actually keep the lights on and the doors open. So the Ombudsman for Victims of Crime has suggested the Department of Justice Victims Fund be expanded to be able to provide core support to those community-based organizations. And again, I'm asking you an obvious question, but do you think this would play an important role in equalizing services across the country?
I think its funding is very important. Where it comes from is a second question, but I find it very hard to understand how in the criminal justice system we can offer alternative sanctions, for example, and that they're not covered by the criminal justice system or by the same budget, the justice budget, and it has to be community-based budgets that are covering it. I mean, you're providing a service to the criminal justice system. So to me, that would be the obvious place, is to treat it with the same way and ensure that the justice system pays for any alternative sanctions that are experienced in that context.
Thank you. That concludes our time, unfortunately. Thank you to the witnesses for your very compelling testimony today. And if there are anything additional that you would like to add, please don't hesitate to send it over to Mr. Clerk, who would be happy to circulate it amongst members. And with that, meeting is now adjourned. Thank you, members.